In our final case today, 2024-12-12, Sherry Cherie Moore, individually and in her capacity as parent, natural guardian, and next friend of PCM, a minor, versus Mercy Medical Center et al. On behalf of the appellant, Mr. Ryan, good morning.
Good morning, Your Honor. My name is Thomas Ryan, and on behalf of the appellants, Cherie Moore and her minor child, PCM, I'd like to reserve 3 minutes for rebuttal. This court should reverse and remand the decision of the trial court and the Fifth District Court of Appeals for 3 reasons. The sham affidavit rule should not be expanded to include unsworn statements, which would include expert reports. We have provided not only persuasive holdings from the Supreme Court of holdings from...
Okay, but isn't this effectively a sworn statement because the expert adopted report as affidavit?
That's the second proposition of law, where when it was adopted in the affidavit, that is the sole time that it was adopted, and that sworn statement then goes towards the credibility and the weight of the testimony because it's an internal contradiction, just as if he was testifying on the stand.
Okay, so if it's internally inconsistent, how does that create a genuine issue of, regardless of whether it should have been struck or not, but how does that create a genuine issue of material fact for summary judgment?
Well, we have accepted as argumentative that there is a contradiction, but his initial report said there was a deviation, and then he got more evidence and then expanded upon it in the affidavit.
Well, did he really get more? I mean, what more evidence did he get?
So in the initial disclosures that were provided to the pro se plaintiff, there were medical records, but it was unclear from reading the records, when did Dr. Menaru know certain information and how was he made aware of it? This is back from 2015. And back then, they did not have external access to the chart. He couldn't review on his phone. He couldn't review from his office. So the only way he became aware of information that we learned through the depositions was that he was speaking to the nurses and they were reading to him information on the screen. So then the contents of those phone calls is what defined the standard of care in this case. Without the depositions, there's no way of knowing.
Okay, but that doesn't seem to get to the issue that's essentially that his first opinion was that they should have ordered a C-section the day before, when he wasn't on duty.
So the C-section, the ordinary C-section, was required on May 28th, the day before the delivery. But when the child did not have oxygen, it became a compounding problem. So the remainder of the day, when the previous physician, Dr. Domingo, was on staff, he didn't perform the C-section. The next day, it transferred back over to Dr. Menaru. And then at that point, it became an obstetric emergency, an emergency C-section.
Well, but the first opinion was essentially the injury was caused by the failure to have the C-section on the 28th.
Compounding. So there's an initial point in time.
Well, I mean, if the injury was caused by it not happening on the 28th, then what happened on the 29th doesn't really matter, right?
No,
it's already caused the injury.
So the injury was a lack of oxygen. It's a fetal distress where every time the Pitocin is causing a contraction, it's another insult upon the fetus. So until the baby is born and breathing on its own, it's compromised. Its oxygen is compromised. So it's a compounding issue from 7 p.m. the day before up until the point in time of delivery, approximately 9 a.m. the next morning.
And so I think the question that Justice DeWine asked was, how does this create a material issue of fact? Can you bring it home in that vein?
So you have to compare the operative note from Dr. Menaru compared to the nursing notes. And the timing of the phone calls are important. The nurses have 3 separate entries in their flow charts. And it's not clear if those are contemporaneously placed or if it's placed after they go back to the nursing station. Dr. Menaru stated that there was 1 phone call that happened around 7:30. You can't square the 1 phone call into the 3 entries. So we took the deposition, and when Dr. Menaru stated, at the second phone call, I told him I would come in. Using that information, the expert then said, well, at 7:30, the flow chart says Dr. Menner will come in. So at that point, he's able to say that's when the standard of care began. It's a 30-minute time window once he's made aware of the condition of the child. So the genuine issue of material fact is involving the float sheets by the nurses and then the doctor's, Dr. Mennerou's testimony versus his operative note.
And that a jury would need to determine.
When was he made aware of this obstetric emergency? Now, to be fair, if he was made aware at 8:20, he did deliver within that 30-minute time window. But there's no way of knowing because his testimony versus his operative note versus the nurses, there's 3 separate options here. And what our expert said is, well, if he was told to come in and you look at the nursing notes, that's when the time period began. So based upon that, genuine issue of material fact, he's able to calculate that 30-minute window as to when he must come in and do the emergency C-section.
Thank you. In light of that, how important is the issue of sham affidavit? I mean, do we need to be making any big changes in what the law is now? Isn't the law just able to be operated within what we've said and the exceptions that are appropriate and explanations for those exceptions? I mean, do we really need to deal with it?
The rule is workable as it stands. This is a unique situation because the trial court forced us to produce our expert reports before discovery had been completed. And we kept telling the trial court, we have produced experts with a limited set of information. And if you look at our motion to compel that was filed in December, we stated specifically that the expert reports that were produced a month earlier were based on a limited set of information. We still do not have full set of records, and we have not taken the deposition of Dr. Menner and the nurses. So it does work, except when you put the cart before the horse, meaning when you have the experts report deadline before the end of discovery.
Okay, but here, the critical statement that the courts below relied on was his report that said that Dr. Domingo, Dr. Menner, and nurse all wouldn't accept by not advocating for a C-section the evening of 5/28/2015. The standard of care required a C-section by 7 p.m. if the tracing did not return to reassuring. Had the C-section been performed by 7 p.m. on 5/28/2015, more likely than not, the child would not have required intubation, and all injuries that occurred as a result of his intubation would have been avoided. Now, that was what they relied on in granting summary judgment, upholding summary judgment. Nothing that came out after the expert report changed anything about that. And you did it? I mean, how?
Yes. So
how did the timing of these notes? That doesn't seem at all relevant to this opinion, which is what seems to be the crux of the whole thing.
So first, finding out that the doctor had no off-site access, that he could not enter the chart, he could not follow along, so he was not aware until he got a phone call from the nurses. Then you have to find out what did Dr. Menner know and when did he know it. And the only way to determine that would be through the depositions of the people that had the conversation over the phone.
But the summary judgment was based on the fact that it had to be done by 7 p.m. on the 28th. And that, nothing you're saying is changing that. And that he wasn't on duty that day.
The injury it's not a single event injury. An ordinary C-section had to be done by 7 p.m. on May 28th. And then it continued on until a delivery occurred. It wasn't a single event injury. And every time that the mother is having a contraction and the child is having issues with blood flow, it's compounding upon the child's respiratory distress.
So in terms of
this argument you're making now really isn't the argument about the affidavit. This is really an argument about the merits of the trial court's decision.
Well, the trial court's decision was based upon a limited set of information. It struck the supplemental report affidavit. So it only allowed us it didn't even actually consider the initial report. So the initial report was insufficient but then it struck the affidavit that was admitted, which I don't, an expert report is not among the materials that can be examined by a trial court. So it can only be the affidavit. Either there's an affidavit or there's not an affidavit. The expert reports are not among the materials.
Unless they're incorporated in an affidavit.
Yeah, it has to be part of the affidavit.
Well, so it was.
The expert report was incorporated into the affidavit that was filed. Rather than retyping all of that same information, he said those information remains true, but I have received additional information. Based upon the additional information, I have new opinions, and he supplemented it accordingly. And if you recall, Your Honor, we did go to the trial court judge and said, we have new evidence. We filed a motion with the court saying we have new evidence, we want to have our experts have new opinions. That wasn't opposed. That was granted. We then took the transcript, sent it to our expert, and within 2 weeks he turned around an updated report. He could have done that had the deposition been done earlier, if we had the records earlier. We were forced to take the deposition on May 6th, the same day that they filed the summary judgment. So we're really through a rock and a hard place based upon the limited information that we were given. Had we had it earlier, we wouldn't have the problem of separate expert report and affidavit.
So Pitocin forces the contractions, and so as long as Pitocin kept up, the contractions are going to continue. And with each contraction, there's a lessening of blood flow to the unborn child.
Yes.
Right. And so, again, the trial court used the sham affidavit to essentially, on summary judgment, kind of knock out what could be a fact that is a genuine issue of fact, to preclude it from going to a jury. Do I have that right?
Correct.
Okay, thank you.
Correct.
But again, going back to the proposition of law, I understand why those have been made because of the way that the trial court used it. We may not, if we deal with that issue, it would be a very narrow issue if we were to reverse, correct? Because again, we'd be reversing on de novo review on summary judgment.
You lost me a little bit. You mean to expand the rule or to keep the rule as it stands?
I would say to keep the rule as it is. If the rule is going to stay as it is, and if it's adequate to stay as it is, there's not that much we have to say about that, correct?
Correct.
Then what would be the crux of our decision then?
At that point, the rule is what it says. It doesn't apply to unsworn statements. Reverse and remand to the trial court and evaluate the summary judgment with the affidavit from Dr. Gubernick attached.
And not all of us, I think, are satisfied that it's an unsworn statement. How do we deal with that in a decision that goes your way? In terms of the nexus created by the affidavit that incorporates it by reference.
Oh, meaning like it became a sworn statement upon the affidavit.
That's what the trial court said, and some of us could feel that way.
Well, then you need to evaluate, well, how did that come about? And how it came about was because the party, the plaintiff, was not allowed to have evidence. That goes to the exception, the second exception, where there's new evidence. And we told the trial court multiple times there was new evidence. And in the motion to compel, we filed a motion for additional time, for leave to supplement our reports. That was granted. It was only after they filed the motion to strike that the court then evaluated it as not supplemental. And it struck it as contradictory.
Thank you.
You're into your rebuttal time.
Thank you, Your Honor. I'd like to reserve the balance of my time for rebuttal. Thank you.
Thank you. Mr. Turkai, good morning.
Good morning. Thank you, Chief Justice Kennedy, and may it please the court. My name is Matt Turkai, and I represent defendant appellee Dr. Godwin Minaru in this matter. Your Honors, the issue in this appeal is critical, particularly in this area of the law where expert support is required to prove or defend against a cause of action, because at its heart, this matter essentially comes down to whether the civil rules should have meaning and be enforced or not.
Why would a trial court force expert reports before the discovery was complete?
Why wouldn't they?
Why would they?
Why would they?
Yeah,
Before
before discovery is complete, before the depositions are taken, so that the expert has as complete a set of facts at hand in order to make an opinion that's going to be reliable.
Sure, yeah. I don't think a court would. Typically, they're set up in which fact discoveries first, then expert reports. Now, ultimately, typically in practice, it's done where discovery is done on a rolling basis. And that's why it's important to note that the civil rules and the sham affidavit rule provide a mechanism within which, if there is discovery that's found after the expert report deadline, new information that wasn't otherwise available at the time the party's expert authored their report, they can supplement it, even if it's a contradictory opinion. The civil rule 26B7 and the sham affidavit rule allow that to happen.
But is there, what the court did was got very technical and said the affidavit which incorporated the earlier unsworn report then made it a sworn report. And I guess I'm saying, are we elevating form over substance if we go along with what the trial court did?
Well, Your Honor, I think it's important, and again, that kind of, to accept appellant's position and reverse both the lower courts, you kind of have to operate under the fact that an expert report, in effect and in practice, is not a sworn statement. And I think to accept that would invite the very bad faith and delay tactics that Civil Rule 26B7 was intended to prevent.
Was it notarized?
I'm sorry?
Was the original report notarized?
No, it was not notarized. But again, with the drafters of Civil Rule 26, the entire purpose of the amendment to the written report rule was to allow the parties to have a full picture of what the opposing side's theories of liability are, and in reliance on that, identify their own experts, identify potential dispositive motion issues, and in fact, even at trial, you can use an expert report to impeach that expert if he or she deviates from it. So
I understand, but why would we consider it to be anything but an unsworn document?
And again, this whole issue is kind of moot to your point, because Dr. Grubernick did incorporate that expert report and his prior statements into his sworn affidavit, thereby converting them, authenticating them into a sworn statement, and thus fitting neatly into the sham affidavit rule.
No, I thought it was kind of like a square peg in a round hole. I mean, it just seemed like an aha moment because it was done that way. Can you help me out here?
I'm not sure if I agree with that characterization. I think, the whole point as to why the sham affidavit rule notes contradicting to a prior sworn statement is essentially whether or not if it's a reliable statement. And that goes back to my original point about how an expert report, the entire purpose of it is reliability. And that's why even Civil 26B7, it meant to eliminate the need to conduct expert depositions altogether. So even the drafters of the civil rules intended an expert's Civil Rule 26 report to have the same effect as a sworn statement.
But
Can an expert testify at trial to things that weren't in his report?
No, Your Honor.
But wouldn't it be better for us to clarify the rule than to just change it with a court decision? I mean, these rules are approved, they go through a process at the court, and then they're also reviewed by the legislature. I mean, is that fair for us to do to litigants?
I'm not sure I understand, Your Honor.
Well, if we're going to essentially change the import of the operation of a civil rule, shouldn't we do that through the public process of changing the rule rather than just saying, oh, now it means this?
I'm not sure we're changing the Civil Rule 26 at all. My whole point is to reverse the lower court's decision. We are essentially rendering Civil Rule 26 meaningless. Civil Rule 26B7 requires, at the time dictated by the trial court, to fully disclose all opinions that an expert may have and the basis for those opinions. Otherwise, they are precluded from raising those opinions at trial. If we then treat those expert reports as unsworn statements, as appellants are attesting here or arguing here, and an expert can willy-nilly just change those opinions, alter them, and contradict them entirely with no sufficient explanation, no new evidence comes to light, like in this case, then that renders that civil rule meaningless, and it renders a dispositive motion practice.
So let's, for the sake of argument or the sake of looking at this, what would have happened if the expert would have said, there was a prior report from me filed in the record, but now that I know this, my opinion is different because of this particular fact that I know from a deposition, and not included the report? Then what?
So if like I said earlier, Your Honor, if a new fact did come to light after the time when the expert may have authored his report, the civil rule and the sham affidavit rule allow that expert to amend or provide a supplemental report. That is not the case here. Dr. Gubernick's new opinion is all centered on the timing on May 29th when Dr. Minoru resumed care of the appellants, and it all stemmed from when he was first notified of fetal distress. The medical records clearly outline when the nurses reached out to Dr. Minoru and advised him of patient status. Dr. Gubernick's operative report, which ironically enough was cited in plaintiff's original complaint, which was filed pro se and didn't have any criticisms of Dr. Minoru, explicitly stated in there that that Dr. Minoru was made aware at 7:30 in the morning from a nurse of fetal heart decelerations. And so, and there's also nursing notes within the medical record that outline each time Dr. Minoru was contacted with regards to the patient's status. And those nursing notes also coincide with the fetal heart tracings that, again, all contained within the records, all within the possession of Dr. Gubernick at the time he authored his report. So in this case, to your point, Your Honor, there was no new evidence. There was no new information that was first disclosed in Dr. Minoru's deposition. Appellants had the opportunity to outline that to the court and say, here, this is why he's raising this new contradictory opinion. It's because X, Y, Z. They could not do that. And the trial court reasonably exercised its discretion and found that it was not based on a new evidence. There was no genuine issue of material fact, and that it was otherwise just an attempt to defeat summary judgment at the 11th hour, which fits squarely within this court's precedent in Byrd and Pettiford in applying the sham affidavit rule.
So there's a lot of discussion on the propositions of law are centered around the sham affidavit rule. But isn't this, it's really just more fundamental about what creates a genuine issue of material fact for trial? I mean, isn't that really the issue here, is whether or not an expert, by proffering an opinion by an affidavit that's contrary or to his expert report, create a genuine issue of material fact?
Yes.
Isn't that's essentially?
Exactly. Yeah. That's one of appellant's other propositions of law, that the court is somehow invading the province of the fact finder. And to your point, that's not the case. The entire purpose of the sham affidavit rule is for the trial court to prevent the fabrication of an issue of fact or credibility. And in this case, the court properly exercised its discretion in finding that this sham, calling what it is, opinion, that was added in response to a motion for summary judgment did not create a genuine issue of fact or credibility. And that's an important note, just again, going to appellant's position on internal inconsistencies, and somehow that takes it out of the sham affidavit rule. And I think the big distinguishing factor that kind of separates this case from the case law that was cited in appellant's briefing on that issue is that Dr. Gubernick did not raise his original opinions for the first time in his April 4th, 2023 affidavit. In other words, and it goes back to my original point, this court cannot treat an expert report that was submitted pursuant to Civil 26 as something other than an unsworn statement. In practice, it has to have the effect of a sworn statement. Even if the expert was not formally sworn in at the time they authored their report, it must have that same effect in order for Civil 26 to work, in order for Civil 56 to work. all his affidavit did, Dr. Gubenick's affidavit did, was formally convert the opinions that were contained within his Civil Rule 26 expert report into sworn statements. And so, to Justice Brunner's point originally, it is a moot issue, I think, in this case, as to whether or not this was sworn, unsworn, because it was converted into a sworn statement. My point is just, we can't to accept appellant's position, which their whole argument is based on, Civil Rule 26 expert reports as an unsworn statement, would invite this type of gamesmanship and bad faith tactics into changing opinions at the drop of a hat in response to a motion for summary judgment when no new evidence came to light.
So we really could focus first and foremost on the de novo review that we would have of a motion for summary judgment and determine whether or not there's a material issue, a genuine issue of material fact here. And then it may be that if we agree with you, we really don't need to deal with the sham affidavit rule, because what really matters to the parties at hand is whether the litigation continues.
Right, and those, I mean, the motion to strike and the motion for summary judgment do go hand in hand, because as the trial court noted, it did consider Dr. Gubenick's original opinions, and it found that and the only opinion that Dr. Gubenick had in his expert report was against Dr. Minero was a catch-all language that he was negligent during the evening of May 28th, 2015. And as the factual record was clear, he was not caring for appellants during the evening on May 28th, 2015. And so based on that, if you're turning just strictly, so it goes hand in hand, because you're eliminating Dr. Gubenick's untimely opinions against Dr. Minero. If you take that out and you agree with us that with appellee that the lower courts were right in striking that untimely contradictory opinion, then all that's left for the court to analyze whether or not there was any meritless viability to any medical claims against Dr. Minero were all based on that very vague, not specific opinion against Dr. Minero. He didn't set forth any specific criticisms of Dr. Minero on that day. And again, the factual record is clear. He wasn't even treating the appellants.
Okay, so you're conceding that if the affidavit were permitted by the trial court, there would be a genuine issue of material fact?
If the affidavit of Dr. Gubenick's was admitted, there would be a genuine issue of material fact?
Right, you're conceding that?
I don't know. I disagree that it would create a genuine issue of material fact because again, if you go back to his opinions, there's two different types. Dr. Gubenick explicitly stated in his original expert report that the injury occurred on May 28th at 7 p.m. That was 12 hours before Dr. Minero ever came back on shift. And so I don't know how you reconcile, even if you let that in, I don't know how you can reconcile those two facts, especially considering that Dr. Minero was not on shift or caring for the appellants at that time.
So the court could have found for you, without getting into the sham affidavit rule, correct?
I don't know if I can go that far. I just to your point, whether or not it creates a genuine issue of fact, again, that's a issue for the trial court. But I do think the two go hand in hand. I think you need to have the sham affidavit rule to eliminate these uncontradicted, unfounded opinions based on evidence that existed at the time.
And I'm going to be quiet and let Justice DeWine go, but I'm just saying, you're concerned about gamesmanship, but if we start getting into changing this sham affidavit rule and calling expert reports that are unsworn, sworn statements, aren't we creating the opportunity for gamesmanship in the future as well?
No, I disagree, Your Honor. I think it would have the reverse effect. If you do treat expert reports in practice, that they have the effect of a sworn statement and those experts are held to those opinions, I think that eliminates gamesmanship. I don't know, because again, the whole purpose of the rule is to invite full disclosure of the opinions and the basis for those opinions at the time the trial court orders that those to be disclosed.
Okay, thank you.
I don't know how taking that away would promote gamesmanship. I think calling them unsworn or in practice treating them as unsworn statements invites gamesmanship because as is outlined in this case, it invites parties to change the opinions without any sufficient explanation. Just to overcome summary judgment.
Well,
Okay.
a party can't overcome summary judgment by pointing to a single witness's say can't say that, well, there's a genuine issue of material fact because I said this at one point and I said this at another point, right?
Right.
I mean, isn't this case that simple?
Yes.
I mean, that's really what it comes down to, is that you can't create a genuine material fact with yourself, and that's essentially what they have done here.
Correct. Again, because the factual record's clear that Dr. Minoru was not involved. So, I mean, that opinion, Dr. Gubenek's original opinion with regards to whether or not Dr. Minoru was negligent on the evening of May 28th, that doesn't overcome or doesn't create any kind of genuine issue of material fact because the factual record's clear he was not caring for the appellants at that time.
Right. I mean, if the same witness says you had to have a C-section on the 28th to avoid injury, and then says again you need to have a C-section by the morning of the 29th, that's not a genuine issue of material fact because it comes from the same witness.
Correct. So, in sum, Your Honors, this case is a perfect illustration of why this court previously adopted the sham affidavit rule. It's essential in preventing individuals, such as appellants in this case, from fabricating false issues of fact or credibility that undermine the integrity of the summary judgment process. It also promotes fairness for both sides of litigation and aligns with Civil 26 by requiring timely disclosure of expert opinions and discourages parties from engaging in gamesmanship when confronted with a motion for summary judgment.
Thank
For
you.
all those reasons, we would ask that the court affirm the lower courts in this case.
Thank you.
Thank you, Your Honor.
Mr. Ryan, you have 1 minute, 2 seconds left.
On the topic of gamesmanship, I just want to note that in this case, we had sought discovery responses for over 6 months, and we were thwarted every attempt. We tried to professionally reach out to the other side. That didn't work. We reached out to the trial court, set conferences. We met with the trial court and continually explained to them, we do not have the information here. We were the victim of the gamesmanship because we were not permitted to get the full set of records, audit trails, access logs, and we didn't take the deposition until the actual last day of discovery.
So why didn't you file a supplemental expert report?
Well, the affidavit is. I mean, that's what it was couched as an affidavit, but we requested additional time to update our expert reports as we asked for leave, and then instead of drafting it as an expert report, it was drafted as an affidavit. They're functionally the same. Versus,
Were you granted the time?
yes, we were granted additional time
Okay.
to supplement the expert reports.
But you did it in the form of the affidavit?
Yeah, it was formed, because 56E requires it to be in the form of an affidavit, not as an expert report.
Okay.
Well, but to be able, for the expert to be able to give the opinions at trial, you need to file an expert report.
Yeah, I mean,
Not just an affidavit opposing summary judgment.
well, you can't submit that report in response to summary judgment, so you can do it either.
No, but you still needed to submit a supplemental report if you were going to testify to that at trial.
Yeah, I mean, it's labeled as an affidavit, but it's those opinions disclosed either through a report or an affidavit functionally are the same, whether he writes a report and then an affidavit incorporating it versus just putting it directly in the affidavit. Disclosure of the opinions are the same. It's just a minor formal difference between how it's presented to the trial court. I see that I'm over my time, Your Honor, and I appreciate it. Thank you.
Thank you. We'll take the matter under advisement. You'll receive a decision from the court. Marshal, please close the court.
All rise. Hear ye, hear ye, hear ye. This open session of the Honorable Supreme Court of Ohio now stands adjourned.